Good morning. I've rarely been introduced as an expert, but I'm humbled by it. My name is Ageet, Onyait. I'm a patent examiner with Uganda Registration Services Bureau, and I'm here in the context of intellectual property. The URSP is the National Intellectual Property Office that handles all IP registrations and protection in Uganda. But my presentation is built on the basis of Dr. Misachi's presentation, because I personally consider Dr. Misachi a very great guy. It's a pleasure to speak after him, because most of the time when I'm doing my research, when I'm doing researches about patents in the medical field, I land on Dr. Misachi's patent applications in the World Intellectual Property Organization website. The MESAU-MEPI talks for the treatment of Marburg and the like. So let me dive straight into the presentation. I didn't have as many pictures, and most of my words are not so bulky, but hopefully it will be interactive enough. So this intellectual property elephant that we have, it has been introduced to us, but I want to throw another definition around. In my eyes, IP refers to all the creations of the human mind. From the time we are born to the time we die, our minds are functioning. So in our minds functioning, we find ourselves creating new things, solving problems, coming up with new things. So everything that the human mind creates is intellectual property. And when we express it in some form or another, then IP is born. The common forms of IP, as referred to by Dr. Misachi, are the trademarks, the patents, the copyright. Then I'll add in there industrial designs and utility models, because they also are defined in our laws. I had hoped to not jump back into what Dr. Misachi has covered and dive straight into the title of my keynote, but I'll just take us to something that we hear a lot about, and that in a country like Uganda is not really that well known, something called the patent. Every so often, people walk into my office and say, I want to trademark my patent or copyright my patent. But like mentioned earlier, the trademarks, the patents, and the copyright are all different forms of IP. The patent, specifically, is an exclusive right granted for any solution, any technical solution to any problem in any field of human existence. And it exists for 20 years. And the basis of it existing, or the reason why we have the patent system, is just for two specific things. Number one is to provide protection for what we create. In the research we do, research is aimed at generating new knowledge, right? If I'm working on something about Marburg, my aim is to find something new that no one else has done. And so, we aim to give protection for the work you have done, the knowledge you've created. And on top of that, in exchange for that protection, you need to disclose so that everyone else doing research does not reinvent the wheel. So, the cycle of research continues in the sense that we create new knowledge because we already know what has been done. So let me jump back into what my presentation is meant to be about, the systems that we can use to protect intellectual property. In this world, we have a statement that man is not an island in himself. I exist in Uganda, but Uganda is in Africa. And Africa is in the world. It's the same thing with IP. There are routes to fire. You can protect your IP nationally through the national route, and that would be with Uganda Registration Services Bureau. Alternatively, you can protect your IP on the regional level. That's in a number of countries in Africa, sub-Saharan Africa. And that would be through the regional route, where you file an application with ARIPO, the African Regional Intellectual Property Organization. Alternatively, you could file the application at the global scale, on the international route. That would be with the World Intellectual Property Organization. But all these forms of protection are based on the law, on what the law says and what the law provides us a basis for. So, in order to be able to protect your application in Uganda, there needs to be a law that says that you can protect it. But before I jump into that, I'll give an analogy of IP. Intellectual property rights are like owning a space of the innovative landscape. You own a small portion. They are analogous to owning land. So if you own land, you get what they call a certificate of title. It's the same thing with IP. When you own that inventive space or that creative idea, you get what you call the title of ownership. So these titles have to be in the law. So to own copyright, the Copyright and Neighboring Rights Act of 2006 gives you that title. Now copyright usually covers things like publications, which so many times in our research we publish and we have our publications out there. It covers things like novels and the books, and I'm sure some of us here are eminent authors of different novels and books that we have come up with. The Trademark Act gives you ownership over the brands, the trade names, the creative branding and logos that you use on your products. The Industrial Property Act gives you titles over the patents that come out of your research and that are generated in that form. The Geographical Indications Act allows us to use words like made in Uganda, or as Dr. said, made in Uganda might not be so well appreciated. And I take that back to what the Bible says. The Bible says a prophet is not accepted in his own home. So when people see made in Uganda, they may be afraid. But when they see made in France, they'll be more comfortable with it. And so with IP, with the ownership that you have over your IP, you're able to transfer it to someone else. So while you came up with the patent for a drug that treats Marburg, you'd be at liberty to sell it to someone else. Because like a land title, it too can be sold. So while you published a book or published your research, you could still be able to sell your copyright over that to somebody. And it's the same way in which IP functions. Like I said, IP also has a regional framework, and that's governed by two protocols that Uganda is party to. That would be the Harare Protocol on patents, utility models and industrial designs, which allows you to file one application that has effect in several countries. And then for the trademarks, it would be governed by the Banjul Protocol, which would still have the exact same effect. Now all these protocols are built on the same framework. They're built to be able to be similar, identical. So if you file an application in the national office, it will be identical to an application on the regional office. It will be filed in the same format, and that format is, as I put there, you need to have a form fully completed in which you specify what right you are seeking. Then you need to pay the fees, as Dr. Misati said. It's not exactly free of charge. And then there needs to be accompanying documents. If you are filing for a patent application, you need to have a description of what you want to protect and specify what you're claiming, that description. And if there are any diagrams to support a description, they'll be included in your application. And then there also is this request for protection, where I specify that I'm seeking protection for this invention of mine that I came up with, or that I had so and so to come up with. And it's a very interesting process that requires you to file your application, after which your application is examined to see if it meets the criteria. The criteria for a patent is it has to be new, it has to be inventive, and it has to have a use. Usually in office we make the joke that if someone came up with a machine that converts oxygen into ozone, so as opposed to it being the breathable O2 that we have, it becomes O3 that destroys all the rubber and everything and our lungs all at the same time. That would have no use or benefit to mankind. And this process is defined by some limitations. There have to be specific timelines for people to see. Maybe we require you to publish your application at some point. So when you search on the internet, you find there are publications of this patent or that patent after a certain period of time, so that the public can view before we give them the certificate. So at the end of it all, you get that certificate of title that we had talked about before. This one I picked out specifically from the system because it's a mobile sickle cell diagnostic tool that was developed by some 2 young ladies, and it was granted the patent in 2016. So ideally they have ownership over everything defined in what they disclose. So they'll be able to stop anyone from copying, using it, putting it up for sale without their permission, which is one of the rights that the holder of this title would have. For example, you have the right to decide who may or may not exploit your invention. You'd also have the right to decide to sell it or permit someone to use it. You'd also have what we don't usually put out here, but the right to object to it being used for specific purposes that you feel depict you in a certain way that is not morally acceptable to yourself. And in the spirit of being brief, I'll end with that.